Uh, Hello friends, Namaskar. I am Anil Kumar Srivastav and present with you for the remaining sections or articles of the Directive of State Policy. I have already discussed the remaining chapters of Directive of State Policy, Part 4 and Fundamental Right. You have got some kind of understanding. I think you will be understanding what is the difference between the two. On the one side, the fundamental right is necessitated because a person is to be made human in two sense, and if these rights are not given to a person, he cannot be made a true person, a true human in the exact sense of the humanity. And on the other side, there is a principle of the goals which have been provided for making the policies of the state governments and central governments, and these rules are also fundamental as far as the making of the policies of the state government and central governments are concerned. There is no lack or deficiency if we talk about the making of the policies of Directive of State Policy. So now I would like to enter in the new article, that is the Article 45. That is the most important section of education. But before we start this, I would like to quote that plants are developed by agriculture and men are developed by education. So education has always been a prominent thing, an important thing for the development of a man. Article 21 provides, which is supposed to be the depository of all the human rights, and it provides that no person shall be deprived of his life or personal liberty except according to procedure established by law. Supreme Court was deciding a case known as Uni-Krishnan case. While deciding the Uni-Krishnan case, the Supreme Court has observed that the education is the direct relation with the human rights, and it directly flows from the Article 21, that is the human rights. So if we see the Article 21 without education, it will be incomplete. So in the Uni-Krishnan case, the Supreme Court has provided that the education, a right to education, is a fundamental right. But in the Uni-Krishnan case, it has also been observed that every state has got some kind of limitation as far as the budget is concerned, or the other grounds of the level of the development. As we can see, the development of the southern state is more than the northern states, and because of many factors or complex factors are involved in it. So on the basis of the decision given by Uni-Krishnan case, the government has made by the 86th Amendment Act the right to education a fundamental right. Now, what was in the original, in the 45, when the Constitution was made, there is a thing that the 6 to 14 years of children should be given compulsory and free education. That the education is compulsory and free, and it will be achieved within the 10 years of the commencement of the Constitution. So these two conditions have been made, that the children should be given compulsory and free education. there shall be no charge for this, and this should be achieved within the 10 years of the commencement of the constitution. But later on, in the light of the judgment given by the Supreme Court in the Unikrishnan case, the government has made an amendment that is also known as 86th Amendment Act in 2002, and it has replaced the old article of 45, and of course it has been distributed in the two sections. Now the 21A has been inserted as a result of the amendment of the Constitution, 86th Amendment. What has been provided in the new 45 article? It has been provided that the state shall endeavor to provide what should it provide? Now, the childhood care, early childhood care. The first thing is early childhood care. And what is early? Early has been considered from 0 to 6. You can know 0 to 6 is the early age, that when the student goes to the kindergarten or in KG1, KG2, senior KG, upper KG, etc. So here in the new section has been created in the 45, and the first thing is that the government should, and government is bound, because the word shall have been provided in it, and meaning thereby the government is bound for the early childhood care of the child, and that early childhood means 0 to 6 years. So, and the another thing what has been provided, education should be given. So early childhood care and education is also included in it, and it is compulsory for the government, because the word shall have been used. So government cannot deny it. So though these things have been used, and as we can see that in the different plan, MDM, it has been introduced in 2004 by the Supreme Court order, because the nutrition level of the student is to be made. What is nutrition? As you already know, that nutrition or the calorie intake is very important for the developing child. If the child is 0 to 6 years, then it needs more calorie for its development, because most of the development is done in early years of age, 0 to 6. So 0 to 6 year is the very important. As you can study and know that when our country was underdeveloped and much underdeveloped, though more and more persons were dying, death rate was more, because there was no early childhood care, no hospitals, no medicines, and no awareness by the people. But we have now got large number of facilities in this. So the death rate and the birth rate both have been reduced. So this article is reshaped, and now to 0 to 6 years the government provides education, gives additional nutrition through the Anganwadi. ICDS program is made for this, you already know. The children of the primary schools and junior high schools are getting MDM, midday meals, and they are giving additional facilities also in the government schools. Why? Because these are the children which will form the basis of the future development. They are future assets. Now another thing, the article 21A has been inserted by 86th Amendment Act. Here the word shall have been used. The states shall provide free and compulsory education for all the children until they complete the age of 14 years, or from 6 to 14 years. So this is the duty of the government, that the child belonging to the age group of 6 to 14 must be given free, without charge, and compulsory, that it has no exception. Every child should be given this kind of education. So now we come to the next article, and as you already know that if it is a fundamental right 21A, then if government does not do its duty, then the person can go to the Supreme Court for the redressal of his grievance, and Supreme Court will give obligatory direction to the government. Now we come to the section 15(1)(k). Here we also find fundamental duties have been given. As you already know that by 42nd Amendment Act in 1976, 10 fundamental duties of the Indian citizen have been provided. But one additional duty have been added by the 86th Amendment Act, that every guardian should give opportunity to his her ward or children from 6 to 14 years an opportunity to go to the schools. So now you can see that a vast change has now been made. So these sections, that is the education, has become a part of our chapter 3rd as 21A, and it has also become a part of that it was a state policy, and also it has become a part of fundamental duties. So these three articles directly related with the education, because our government knows that without education no person can be converted into a true human being, or he cannot be asset. If he is not skilled, then his value of output will be less. So now we come to the next section, Article 14. Article 44. As you already know that Article 44 has been the very important article, and it has already been discussed. It has been already discussed. The most important article of this section is the Article 44. Here we find that one, Jitendra and Pradeep and G.C. Ghosh. Jitendra, Pradeep and G.C. Ghosh. These are the three persons which I am highlighting. Jitendra, Pradeep and G.C. Ghosh. For the first time, Jitendra was married by a certain woman named Meena Mathur, and he, after some years, he has converted himself into Muslim, because the Muslims have a right to marry with 4 ladies. Here the real question arises, and similarly the next person which I am discussing about is Pradeep. Pradeep was also a Hindu, and a marriage was performed by Gita, through Gita to Gita, and after some time he fled with some other lady and converted to Islam. And similarly, in the third case, Also, G.C. Ghosh was married to Smita Ghosh, but later on he also married with Vinita and converted to Islam. So the first case which went to the court for the problems arising out of these conversion to the Muslim, because the Muslim Islam has given the theory of foremarriage. But now the main problems arises when a certain Hindu women or maybe Muslim women, I shall discuss about them also, if she is left and her husband left her, what will happen? She will be left without anything, without any kind of money. How can she be maintained? How she can derive his livelihood? These are the problems. And if there are children also, then how can they be maintained? How their education can be done? How they can, from where the budget will come for their clothings, for their houses and for other things. So these type of problems arises. And in all three cases we find that there were Hindu and they married with the Hindu rituals, but ultimately they converted to Islam for to marry with the another lady, because Islam gives right to a person to marry with second marriage, and it shall not be any kind of punishment will be given to him. But the Supreme Court faced this famous case. These three cases and some more cases were enlisted in the name of the Sarla Mudgal case. And Sarla Mudgal case came in 1995 before the Supreme Court. The Supreme Court, after observing all the implications of this, what will happen to a woman and who is left without her husband? She has no money, she has no house, she has no clothes. What will happen to their children? These are the problems to be faced. So, for their enjoyment, the husbands have converted to Islam and they married to another girl. So these were the questions before the apex court in Sarla Mudgal case. The Supreme Court has decided that this is the very important case, and the Supreme Court has said that the Hindu marriage cannot be and can never be dissolved, and it can only be dissolved after the decree under Hindu Divorce Act section 13. Until and unless that decree is passed, there shall be no dissolution of Hindu marriage. If a person converts to the other religion and gets married with another girl, this is absolutely wrong, and this will be covered under section 494 of the section of IPC, and that is punishable, and that is bigamy. So if a person is converted to Islam and originally he was a Hindu and he marries another girl, his marriage still exists. So many of them have come to their original spouses. But this problem remained very important. And I shall discuss you some other cases with the history of the Uniform Civil Code. So, Uniform Civil Code, if we talk about Uniform Civil Code, what is this? For this, in 1833, it has been provided that there should be a commission, and that commission was constituted by British government under the leadership of the Macaulay, and Lord Macaulay said that there should be no law, common law for the personal laws, for the civil codes. He recommended for in the other fields that there should be a common law, but in the personal fields, divorce, marriage, succession and inheritance, in all these cases he escaped in his review. And on the ground of these, the development was taking place. CPC was formed, and other in 1869 Goa was made the first state to apply the Uniform Civil Code, because it had been passed in the in Portugal, and Indian Marriage Act has also been passed in 1972, which covers the Christians, and Indian Divorce Act and many other acts have also been passed. And till 1997, till 1937, we find that the Muslim law was also codified. So Hindu law has been codified, Parsi law has been codified, Christian law has been codified, and in 1944 a committee was formed, and that applied for the common civil code. And as we know that there was a hot debate in the Constituent Assembly that Uniform Civil Code should be implemented immediately, but there were the oppositions from both the sides, and because of the oppositions from both the sides, the Bhimrao Ambedkar did not include in the fundamental right, and it was inserted in the Article 44, that was state policy, and he thought that when the time will come and it will be codified. And during the 4 years, 47 to 51, during the first ministry, he tried his best to pass a Hindu code bill, but because Dr. Rajendra Prasad was opposed to it, because the Constituent Assembly did not represent all the communities of the India, and he wanted that this must be passed after the 1952 general elections, and that was done. In 1956 we got that the many acts. In 1955 the Indian Marriage Act, Hindu Marriage Act was passed, and in 1956 other acts, succession and divorce and Adoption Act and Guardianship Act, Inheritance Act, Succession Act, all have been passed. So now we come to these things. After the most important thing have happened when in 1985 a lady came to the apex court from Indore. A famous Wakil Muhammad Ahmad, who was earning nearly 60,000 per year, was of the view that no maintenance should be given to the Shah Banu, his wife, at the age of 65. And the judgment was given by the Indore Sessions Court, and thereafter the High Court has ratified, and then the top High Court advocate Mr. Muhammad came to the challenge it in the Supreme Court, and the Supreme Court and then Chief Justice of India, a committee, a constitutional bench was constituted for deciding this case, and the Supreme Court unanimously gave a decision in favor of the Shah Banu on 23rd April 1985, and this judgment was that the Article 125 of the CRPC applies to all the Indians, and so the maintenance should be given to this lady as per the Article 125(3) and not on the basis of the Sharia law or not on the basis of the Muslim law. This was the famous case, but later it was amended in 1986. The then Prime Minister of India moved a bill to annul the impact of this, and the Muslim Women Protection Act was passed in 1986. And thereafter we find the Sarla Mudgal case, and thereafter in 1997 in Tahira Bano case, the Supreme Court Judge B.R. Krishna Iyer said all the best practices of all the religion in the field of the common civil code should be taken into account, and a best practice should be made. And thereafter we find that in 2001 important case, the Supreme Court has held that the Muslim women should be given the right of maintenance under 125(3) until the children become major. And in Supreme Court again in Pragati Barghi's case annulled the section 10 of the Indian Divorce Act, saying that the case was filed by Pragya, and in this case the husband was saying that there can be no divorce in accordance with the Indian Divorce Act, which applies to the Christianity, because only on the basis of the desertion, but the wife should also prove that there is a adultery also. The Supreme Court has annulled or set aside the section 10 of the Indian Divorce Act. And similarly, in the famous case Seema versus Anish Kumar or something like this, in Seema case, the Supreme Court has clearly laid down that there are the problems of wives becoming helpless, of the children becoming helpless, and the person is denying the marriage. There are a lot of problems are developing because we have no law, no active law for the civil code. And Supreme Court has the two-judge bench, Justice Pasai had laid down a very prominent section, and he said that every state of India should within the 3 years make compulsory marriage registration, and this should be put before the Supreme Court. So this was the basic. Seema case was a very important case as far as the common civil code is concerned. And in further cases in 2007, in 2007 and 2009 Savannah case, and thereafter in Lily Thomas case 2012, Supreme Court gave a direction that we cannot intervene in the Muslim Women Protection Act 1986. We cannot give any direction because it is in the sphere of the legislature. But a famous case was again came in 2017, and that is also known as Sara Bano case. In this case, by the majority of 3-2, it has been said that the triple talaq is unconstitutional. So we come to the end, and after that in 1919 this talaq has been made punishable, and if some person commits triple talaq, then he will be punished and for 3 years. So this is the story of the women, whether it is Hindu women or the Muslim women, both were suffering because of the non-making of the common civil code. The common civil code, Supreme Court judge has said that since 1950 many governments has come and many governments has gone, but no one has given practical shape to the mandate of the constitutionality of the section 44. As we have done away with the sati, so this article can also be made. So I would like to end with this, कि that सभी धर्मों का मान रहे, बट सभी मजहबों का मान रहे, पर सबसे बड़ा मजहब संविधान रहे. थैंक यू वेरी मच.